Hello everyone, welcome to Unacademy Judiciary. So in today's video, I'm going to discuss important sections of Indian Partnership Act for West Bengal Judiciary Exam. Plus, we are going to rapidly revise the Indian Partnership Act. So, अगर आपको rapidly, if you want to do rapid revision for West Bengal Judiciary Exam, then this batch is starting from 23rd of Jan onwards. So you can just join the classes. This is going to be a 3 months batch. So all the subjects according to your syllabus will be completed in these 3 months, and these are the educators that will be teaching you along with me. And you can just use this code VB Law. You will get 10% off on Unacademy subscription. Details and all each आपको description box में मिल जाएंगी. So let's start with the Indian Partnership Act. So this is a small subject, but every subject is important to clear the exam. So we are going to see what is partnership. सबसे पहले तो पार्टनरशिप होती क्या है. दिस इज डिफाइंड इन योर सेक्शन 4. ये हमें कहाँ पे डिफाइन किया है. दिस इज डिफाइंड इन सेक्शन 4 दैट व्हाट इज अ पार्टनरशिप. So partnership means this is the relation between partners who have agreed to share the profits of the business carried on by all or any of them acting for all. So the persons जो agree करें कि we are going to share the profits of a business, whether ठीक है हो सकता है कि that is carried on by all. If A B C D चार पार्टनर्स है कि चारों मिलके बिजनेस को चलाएं, या फिर हो सकता है कि A और B चलाएं बट वो एक्ट जो है सबके बिहाफ पे कर रहे हैं. सो दिस इज द मीनिंग ऑफ पार्टनरशिप दैट इज गिवन अंडर सेक्शन 4. Now Indian Partnership, before the passing of the Indian Partnership Act, so Indian Partnership Act जो है this came into force on 1st day of October 1932. So when this act came into force, this came into force on 1st day of October 1932, but except section 69 which shall came into force on 1st day of October 1933. So except these sections, all the sections of the Indian Partnership Act came into force in 1932 on the 1st day of October. Now the presidential assent, this act को presidential assent कब मिला था? On 8th of April 1932, the president gave the assent to this act. So before the passing of the Indian Partnership Act, all the provisions of the partnership were contained in Indian Contract Act. तो जब ये एक्ट पास नहीं हुआ था, तो जितनी भी प्रोविजंस थी इंडियन पार्टनरशिप एक्ट की, दैट वाज कंटेन्ड इन द इंडियन कॉन्ट्रैक्ट एक्ट. तो चैप्टर 11 sections 239 to 266 of the Indian Partnership Act. Chapter 11 sections 239 to 266 of the Indian Partnership Act deals with what? Deals with the of the Indian Contract Act. These contains the provisions regarding the partnership. But ये जो provisions थी, these provisions were neither adequate not satisfactory. So that's why these provisions were repealed, and with the development of the trade in India, the necessity of a new legislation was deeply felt. So this Indian Partnership Act is based on the English Partnership Act 1890. So this Indian Partnership Act is based on the English Partnership Act 1890 के ऊपर जो है ये based है. So when this act came into force, as we have already seen, this came into force on 1st day of October 1932, except section 69 which shall came into force on 1st day of October 1933. Now we have seen what is the definition of partnership that is given in section 4. पार्टनरशिप दो तरह की होती है. एक होती है पार्टनरशिप एट विल. वन इज पार्टनरशिप एट विल, अनदर इज दैट इज पर्टिकुलर पार्टनरशिप. So this is defined where? This is defined in section 7. This is defined in section 8. So partnership at will means जहाँ पे आपने ड्यूरेशन स्पेसिफाई नहीं की, where the duration of the partnership is not specified and the determination of the partnership is not specified, then that is partnership at will. Where the duration and determination of the partnership is not specified, that is the partnership at will. मतलब कि आप उसको कभी भी खत्म कर सकते हो. Particular partnership means a person may become a partner with another, कि अगर कोई किसी पर्टिकुलर एडवेंचर या अंडरटेकिंग के लिए स्पेशल एक पार्टनरशिप बनाई गई है, देन दैट इज द मीनिंग ऑफ पर्टिकुलर पार्टनरशिप अंडर सेक्शन 8. Now partnership how the partnership arises, whether that arises from the status of the parties or from the contract. So the relation of the partnership arises from the contract, not from the status. This is given in section 5. जो रिलेशन है पार्टनरशिप का वो अराइज करता है कॉन्ट्रैक्ट से, ना कि स्टेटस से. तो जो मेंबर्स हैं हिंदू अनडिवाइडेड फैमिली के, इफ दे आर कैरिंग ऑन ए फैमिली बिजनेस, अगर मेंबर्स हैं वो फैमिली बिजनेस कैरी ऑन करें, सो दे आर नॉट पार्टनर्स इन द फर्म. व्हाई? बिकॉज उनमें जो पार्टनरशिप है दैट डिड नॉट अराइज फ्रॉम द कॉन्ट्रैक्ट, बट स्टेटस, उनकी जो फैमिली का स्टेटस, दे आर मेंबर्स ऑफ द हिंदू जॉइंट अनडिवाइडेड फैमिली, सो दैट्स व्हाई दे आर कैरिंग ऑन द बिजनेस टुगेदर. So they are not partners in the firm. So this says the members of the Hindu undivided family carrying on a family business, or a Burmese Buddhist husband and a wife carrying on a business as such, they are not partners in such business. So two Hindu joint families cannot unite to constitute a partnership. दो हिंदू जॉइंट फैमिलीज यूनाइट नहीं कर सकती हैं पार्टनरशिप को कॉन्स्टिट्यूट करने के लिए, but their managing members may become partners, each having the rights and duties with reference to their respective families. But जो उनके managing members हैं वो partners बन सकते हैं, each having the rights and duties with reference to their respective families. Now what is the mode of determining existence of partnership? कि partnership exist करती है या नहीं, वो determine कैसे होगा? So in determining whether a group of persons is or is not a firm, या फिर whether a person or is that is a person is a partner or not. So what is needs to be seen is the real relation between the parties. What is the real relation between the parties, that is to be seen. So if the partners are sharing profits or gross returns arising out of the property, that does not make them personal partners. So if anyone is if anyone is an employee in the company and the company को कोई profit हो गया and the employee gets a bonus, so that does not mean that he become a partner in the firm. So what is needs to be seen for determination? The real relation क्या है parties के बीच में, that will be seen. This is according to your section 6. So if there is a lender of money to persons engaged or about to engage in a business, the servant or agent as remuneration what he receives, अगर widow or child of a deceased partner receives an annuity, or a previous owner or part owner of the business as consideration for the sale of goodwill or share thereof, so that does not of itself make the receiver a partner with the persons carrying on the business. Now section 7 and 8 we have already discussed. Now अगर partner की किसी भी fraud की वजह से, if the partner does any fraud to the firm, और या फिर पार्टनर ने अगर विलफुल निग्लेक्ट किया है, तो if the partner has done any fraud to the firm, then he needs to वो indemnify करेगा firm को. Every partner shall indemnify the firm for any loss caused to it by his fraud in the conduct of the business of the firm. Similarly, if the partner has committed any willful neglect, if the partner has done any willful neglect एंड फर्म को कोई लॉस हो जाता है, देन उसके लिए भी पार्टनर जो है इंडेमनीफाई करेगा फर्म को अकॉर्डिंग टू सेक्शन 13(1)(f) के अकॉर्डिंग. तो फ्रॉड इज गिवन इन सेक्शन 10, विलफुल निग्लेक्ट इज गिवन इन सेक्शन 13(1)(f). नाउ डिटर्मिनेशन ऑफ द राइट्स एंड ड्यूटीज ऑफ द पार्टनर्स बाय कॉन्ट्रैक्ट बिटवीन द पार्टनर्स. So the mutual rights and duties of the partners of a firm may be determined by the contract between the partners, and that contract may be expressed or may be implied by a course of dealing. तो ऐसे कॉन्ट्रैक्ट को ऐसा नहीं है कि वेरी नहीं किया जा सकता. Such contract may be varied by the consent of all the partners, and the consent may be expressed or implied by a course of dealing. So this is what is written in section 11. So we have already read under Indian Contract Act, if anyone does an agreement in restraint of trade, that is what? So you are free to do any trade. This is the right that the constitution provides. So every person is free to profess any trade that he wants. तो अगर कोई restrict करता है, अगर कोई agreement बनाता है, that is void under section 27 of the Indian Contract Act. But if anyone does any agreement in restraint of trade of partnership, anyone does any agreement in restraint of trade in partnership under section 11, that is a valid contract. वो एक valid contract होगा. So that this is what is written in section 11(2). This says notwithstanding anything contained in section 27 of the Indian Contract Act, Such contracts may provide that a partner shall not carry on any business other than that of the firm while he is a partner. So every person has a right to carry on the conduct of the business. If there is any difference that arise in the ordinary matters that is connected with the business of the firm, then जो majority decide करेगी, that is the final decision. So if any difference arises as to the ordinary matters के regarding, majority का decision final होगा. But if there is a change that needs to be made in the nature of the business, then वहाँ पे ठीक है सबका decision होगा. So without the consent of all the partners, then no change can be made in the nature of business of the firm. This is what is written in 12C. This is any difference arising up to ordinary matters connected with the business may be decided by majority of the partners, and every partner shall have the right to express his opinion before the matter is decided, but no change may be made in the nature of the business without any consent of all the partners. So every partner has a right to have access to and वो inspect कर सकता है copy of the books of the firm. Now what is included in the property of the firm? So goodwill of the business is also included in the property of the firm. The property of the firm shall be used exclusively for the purposes of the business. The property है firm की, so exclusively that can be used only for the purpose of the business of the firm. If any partner derives any profit for himself, अगर वो खुद के लिए कोई profit drive कर लेता है for his personal benefit from any transaction of the firm or from the use of the property or the business connected of the firm or the firm name, then he shall account for that profit and pay it to the firm. अगर कोई partner business को carry on करता है, if any partner carries on any business of the same nature as that competing with that of the firm, then he shall account for and pay to the firm all profits made by him in that business. If a partner carries on any business of the same nature and competing with that of the firm, then he shall account for and pay to the firm all profits that is made by him in that business. Now the partner is the agent of the firm for the purpose of business of the firm. So one is the express authority, that is expressly written, expressly जो provide की जाती है. One is implied authority. So authority of the partner to bind the firm that is conferred by section 19 is his implied authority. So if there is any absence of usage or custom of a trade to the contract, the implied authority of a partner does not empower him. That does not empower him to submit a dispute relating to the business of the firm. He cannot open a banking account on behalf of the firm in his own name. He cannot compromise or relinquish any claim or portion of the claim of the firm. He cannot withdraw a suit or proceeding filed on behalf of the firm. He cannot admit any liability in a suit or proceeding against a firm. He cannot acquire immovable property on behalf of the firm. He cannot transfer immovable property belonging to the firm, and he cannot even enter into partnership on behalf of the firm. So अगर custom or usage allow करता है, then that is a separate thing. Otherwise, the implied authority of a partner does not empower him to do all these things. So he cannot do all these things that we have seen. Now the partners in a firm may by contract between the partners. So the partners in a firm may by contract between the partners, they can extend or restrict the implied authority of any partner. So they can extend or restrict the implied authority of any partner. So any act done by a partner on behalf of the firm which falls within his implied authority binds the firm. Which falls within his implied authority that binds the firm unless the person with whom he is dealing knows of the restriction or does not know or believe that the partner to be a partner. Now, what is the partner's authority in an emergency? If there is any emergency, a partner has authority to do all such acts for the purpose of protecting the firm. He is in authority. He will do all such acts for the purpose of protecting the firm from the loss that a that a person of ordinary prudence would have done in his own case. So this is the partner's authority in an emergency. तो अगर पार्टनर कुछ भी इमरजेंसी के टाइम करता है तो द फर्म विल इंडेमनीफाई हिम फॉर दैट, फर्म उसको इंडेमनीफाई करेगी उस चीज के लिए. तो दिस वाज रिटन वेयर, दिस वाज रिटन इन सेक्शन 13 के ई में ये दिस इज गिवन. In section 13E, this is given. Next is that is what is the effect of admissions by a partner. An admission on representation made by a partner concerning the affairs of the firm is evidence against the firm. An admission on representation made by a partner concerning the affairs of the firm is evidence against the firm if it is made in the ordinary course of the business. That is made in the ordinary course of the business, then that is the effect of admission by a partner. Now, what is the liability of the partner for the acts of the firm? So, every partner is liable. Every partner is liable jointly with all the other partners. Every partner is liable jointly with all the other partners and also severely for all the acts of the firm done while he is a partner. Now, what is the liability of the firm for the wrongful acts of a partner? So, whereby the wrongful acts or omission of a partner acting in the ordinary course of the business of the firm or with the authority of his partners, loss or injuries caused to any third party or any penalties incurred, the firm is liable therefore to the same extent as a partner. तो रॉन्गफुल एक्ट या ओमिशन की वजह से अगर पार्टनर की स्टार्ट इज एक्टिंग इन द ऑर्डिनरी कोर्स ऑफ द बिजनेस, अगर कोई भी लॉस या कोई भी इंजरी होती है टू एनी थर्ड पार्टी, तो फर्म लाइबल है सेम एक्सटेंट के लिए, दैट इज एज द पार्टनर. नाउ होल्डिंग आउट, व्हाट इज होल्डिंग आउट? सिमिलर प्रिंसिपल हम इंडियन एविडेंस एक्ट में भी पढ़ते हैं under section 115 of the Indian Evidence Act, that is estoppel. So this says any person who by words spoken or written, any person who by words spoken or written or by conduct, if he represents himself or knowingly permits himself to be represented to be a partner in the firm is liable as a partner in the firm to anyone who has on the faith of any such representation given credit to the firm. So whether the person representing himself or represented to be a partner does or does not know that the representation has reached the person so giving the credit. तो एनी पर्सन, ठीक है, जिसने वर्ड से स्पोकन हो, रिटन हो या बाय कंडक्ट, अगर वो रिप्रेजेंट करता है या नोइंगली परमिट करता है टू बी रिप्रेजेंटेड, इज लाइबल एज ए पार्टनर इन द फर्म. वो लाइबल है एज ए पार्टनर इन द फर्म टू एनी फर्म हु हैज ऑन द फेथ ऑफ सच रिप्रेजेंटेशन. अगर उसने उस रिप्रेजेंटेशन के फेथ के ऊपर अगर उसने क्रेडिट दे दिया है, ठीक है, वेदर द पर्सन, चाहे उसको पता है नहीं पता है, दैट डज और डज नॉट नो दैट द रिप्रेजेंटेशन हैज रीच द पर्सन सो गिविंग द क्रेडिट. So this is very important. There is a landmark judgment regarding this, that is Kauf versus Jardin का एक landmark judgment है इसके regarding. Section 30 is very important. See, a minor cannot be a part. Minor के साथ कोई contract नहीं हो सकता है. Minor cannot form a contract, ठीक है, with a minor, because contract के लिए 18 age चाहिए होती है. That is according to the Indian Majority Act. But with the consent of all the partners for the time being, he may be admitted to the benefits of the partnership. बट कंसेंट के साथ उसको एडमिट किया जा सकता है टू द बेनिफिट्स ऑफ द पार्टनरशिप. तो ऐसे माइनर का राइट है वो शेयर कर सकता है टू सच शेयर ऑफ द प्रॉपर्टी और ऑफ द प्रॉफिट्स ऑफ द फर्म एज मे बी एग्रीड अपॉन, और एंड ही मे हैव एक्सेस टू एंड इंस्पेक्ट एंड कॉपी एनी ऑफ द अकाउंट्स ऑफ द फर्म. सच माइनर्स शेयर इज लाइबल फॉर द एक्ट्स ऑफ द फर्म. ऐसे माइनर के शेयर लाइबल हैं फर्म के एक्ट के लिए बट द माइनर इज नॉट पर्सनली लायबल फॉर एनी सच एक्ट। बट माइनर जो है वो पर्सनली लायबल नहीं है ऐसे किसी भी एक्ट के लिए, बिकॉज माइनर खुद तो जो है ही कैन नॉट बिकम अ पार्टनर इन द फर्म। उसको सिर्फ जो है कंसेंट के साथ सारे पार्टनर्स की, ही इज ओनली एडमिटेड टू द बेनिफिट्स ऑफ द पार्टनरशिप। Now this says at any time, at any time within 6 months of his attaining majority or his obtaining knowledge that he has been admitted to the benefits of the partnership, whichever date is later, ठीक है, जो भी डेट लेटर है, such person may give public notice। ऐसा पर्सन जो है पब्लिक नोटिस दे सकता है कि क्या वो पार्टनर बनना चाहता है फर्म में या नहीं बनना चाहता, एंड दैट शेल डिटरमाइन हिज पोजीशन एज रिगार्ड्स द फर्म। तो कितने टाइम में उसको नोटिस देना होगा? विद इन 6 months ऑफ हिज अटेनिंग मेजोरिटी। अगर उसने 6 महीने में जो है नोटिस नहीं दिया, देन ही शेल बिकम अ पार्टनर इन द फर्म ऑन द एक्सपायरी ऑफ द सेट 6 months। तो वो पार्टनर बन जाएगा फर्म में उस 6 महीने की एक्सपायरी पे। So where any person has been admitted as a minor to the benefits in the firm, तो अगर ऐसे पर्सन ने पार्टनर बन गया तो उसकी राइट्स एंड लाइबिलिटीज एज अ माइनर सिर्फ उसी डेट तक कंटिन्यू करती हैं जिस दिन वो पार्टनर बन जाता है। वाई? बिकॉज अब तो वो पार्टनर बन गया, तो उस डेट के बाद अगर कोई भी एक्ट किया जाता है देन ही इज लाइबल टू द थर्ड पार्टीज फॉर ऑल द एक्ट्स ऑफ द फर्म डन सिंस ही वॉज एडमिटेड टू द बेनिफिट्स ऑफ द पार्टनरशिप, and his share in the property and profits of the firm shall be the share to which he was entitled as a minor. But suppose such person elects not to become a partner in the firm, then his rights and liabilities वो उसी दिन तक कंटिन्यू करेंगी जिस दिन वो चूज कर लेता है, जिस दिन वो पब्लिक नोटिस दे देता है कि मैं पार्टनर नहीं बनूंगा। उसका शेयर भी सिर्फ उन्हीं एक्ट्स के लिए लायबल होगा, ठीक है, जो उसके पहले किए थे नोटिस के पहले। सो हिज शेयर शैल नॉट बी लायबल फॉर एनी एक्ट्स ऑफ द फर्म डन आफ्टर द डेट ऑफ द नोटिस। He shall be entitled to sue the partners for his shares of the property and profits in accordance with the subsection 4. So this is regarding कि a minor कब पार्टनर बन सकता है, ठीक है, he cannot become a partner but he may be admitted to the benefits of the partnership. Now the next is that is section 31, introduction of partner. So no person shall be introduced as a partner into a firm without the consent of all the existing partners. So with the consent of all the existing partners only he can become a partner in the firm. So partner, person who is introduced as a partner in the firm that does not become liable for any act of the firm done before he became a partner. So a person who is introduced as a partner in the firm does not thereby become liable for any act of the firm done before he became a partner. Now, how a partner can retire? एक पार्टनर रिटायर कैसे हो सकता है? विद द कंसेंट ऑफ ऑल द पार्टनर्स इन अकॉर्डेंस विद एन एक्सप्रेस एग्रीमेंट बाय द पार्टनर्स, या फिर वो नोटिस दे के इन राइटिंग में टू द अदर पार्टनर्स दैट ही हैज एन इंटेंशन टू रिटायर। नेक्स्ट इज पार्टनर्स कैन बी expulsion of partner is given in section 33, that a partner may not be expelled from the firm by any majority of the firm if that is in the save in the exercise of the good faith of power. Where a partner in the firm is adjudicated as insolvent, then he ceases to be a partner on the date on which the order of adjudication is made. तो अगर कोई पार्टनर इंसॉल्वेंट हो जाता है उसी दिन से पार्टनरशिप फर्म में सीज कर जाएगा when the order of adjudication is made, whether or not the firm is thereby dissolved. Now the most important sections are next is that is dissolution of firm के regarding. So the dissolution of partnership between all the partners of the firm is called the dissolution of the firm. So firm may be dissolved with the consent of all the partners or in accordance with the contract between the partners, या फिर in accordance with the contract between the partners a firm can be dissolved. Now what is the meaning of compulsory dissolution? A firm is dissolved by the adjudication of all the partners or of all the partners but one as insolvent by the happening of an event which makes it unlawful for the business of the firm to be carried or for the partners to carry on its partnership. So dissolution on the happening of certain contingencies. अगर पार्टनरशिप फर्म फिक्स टर्म के लिए है तो उसकी एक्सपायरी भी हो जाएगी। अगर वो वन और मोर एडवेंचर्स या अंडरटेकिंग के लिए अगर वो कंप्लीट होगी, पार्टनर की डेथ होगी या फिर by an adjudication of the partner as an insolvent. Next is that is dissolution by notice of partnership at will. So where the partnership is at will, the firm may be dissolved by any partner giving notice in writing to all the other partners. तो अगर पार्टनरशिप एट विल पे है तो फर्म डिसॉल्व हो सकती है बाय एनी पार्टनर राइटिंग में नोटिस देके बाकी सारे पार्टनर्स को ऑफ हिज इंटेंशन टू डिसॉल्व द फर्म. तो फर्म किस दिन से डिसॉल्व होगी? द फर्म इज डिसॉल्व फ्रॉम द डेट दैट इज मेंशन्ड इन द नोटिस. अगर कोई डेट नहीं मेंशन्ड है देन फ्रॉम द डेट ऑफ कम्युनिकेशन ऑफ द नोटिस. So where the partnership is at will, the firm may be dissolved by any of the partner giving notice in writing to all the other partners of his intention to dissolve the firm. अगर कोई डेट मेंशन है तो उस दिन से डिसॉल्व होगी. इफ द डेट इज नॉट मेंशन देन फ्रॉम द डेट ऑफ कम्युनिकेशन ऑफ द नोटिस. Section 44 says regarding the dissolution by the court. This says at the suit of a partner, the court may dissolve a firm on any of the grounds that is mentioned here. तो पार्टनर अगर इन अनसाउंड माइंड का बन गया है इन विच द सूट जो है नेक्स्ट फ्रेंड ऑफ द पार्टनर या दूसरा कोई पार्टनर जो है सूट फाइल कर सकता है. इफ द पार्टनर हैज बिकम परमानेंटली इनकेपेबल ऑफ परफॉर्मिंग हिज ड्यूटीज, इफ द पार्टनर इज गिल्टी ऑफ ए कंडक्ट जिसने प्री जुडिशली इफेक्ट किया है बिजनेस जो है वो कैरी ऑन नहीं किया जा सकता. इफ द पार्टनर हैज कमिटेड द ब्रीच ऑफ एन एग्रीमेंट, अगर पार्टनर ने अपना शेयर जो है वो ट्रांसफर कर दिया है. If the business of the firm cannot be carried on save at a loss or any other ground on which renders it just and equitable that the firm should be dissolved. So these are the grounds where the court can dissolve the firm. Now next is how the settlement of accounts between the partners. What is the mode of settlement of accounts between the partners? So in settling the accounts of a firm after dissolution, the following rules shall subject to agreement by the partners be observed. सबसे पहले तो losses होंगे. Shall be paid first out of the profits. So सबसे पहले losses जो हैं किससे पे किए जाएंगे? Out of profits. Next out of the capital and lastly अगर जरूरत पड़ी then by the partners individually in the proportion in which they were entitled to share profits. The assets of the firm including any sums contributed by the partners to make deficiencies of the capital shall be applied in the manner and order. इसमें अप्लाई होंगे. सबसे पहले तो फर्म के डेट्स पे होंगे टू थर्ड पार्टी. Then in paying to each partner relatively what is due to him from the firm for advances as distinguished from capital. Next is in paying to each partner relatively what is due to him on account of the capital. Next is the residue, if any, shall be divided among the partners in the proportion in which they were entitled to share the profit. So these were some important sections of the Indian Partnership Act regarding your exam. Now registration of firm, the state government जो है of any state में by notification direct कर सकती है. shall not apply कि state के ऊपर ये apply नहीं होंगी. रजिस्ट्रार्स की अपॉइंटमेंट कौन करता है? स्टेट गवर्नमेंट अपॉइंट करती है. एप्लीकेशन फॉर रजिस्ट्रार दैट इज गिवन अंडर दिस सेक्शन. देन वन मोस्ट इंपॉर्टेंट सेक्शन इन दिस इज दैट इज सेक्शन 69. The registration of a firm is not compulsory, that is optional. So no suit to enforce a right arising from a contract or conferred this by this act shall be instituted in any court or behalf of the person. So what is the effect of non-registration? That is given under section 69. So if you want to rapidly revise your Indian Partnership Act, other subjects, then you can just join this batch. You can make the notes in the class, one-liners according to your pre-exam. So we'll do all the provisions, all the subjects. Take along with me, other educators will be taking your classes. So another important thing is learners. This is a Safalta Bihar Judiciary Batch. You can just use this code to get 10% off on this batch. This has started on 12th of Jan. So different states of different batches are running on Unacademy. Like UP के लिए अलग से batch है. So along with the batches, there is the test series that you can give. So these are the tests that every month Unacademy conducts. So along with the theory classes, you have access to this, and these are the prices that you will get after applying this code VB law. So you can just save your money and you can prepare for judiciary. So thank you so much, learners. I am just ending the session here only.